Oftentimes a client will ask me, how in the world could the police have searched my car? They didn't have a warrant. But let me say time and time again, that's the case. Wherever you drive, whatever you have in your car, at any moment could be subject to a search without a warrant. In the state of California, as well as in the United States of America, there are certain exceptions to the search warrant requirement. And there are a number of those exceptions that apply to your car. Yes, we often think they shouldn't get to search my person or property without a search warrant. But because of the nature of a car, its mobility, and the easy nature for items in that or evidence in that car to be destroyed or moved, the Supreme Court of both the state of California and the United States have come up with a number of exceptions that apply to cars. So oftentimes, when you're being investigated by a police officer, your car ends up being searched. One of the most common ways that an innocent person's car gets searched is that they reluctantly allow it to by giving an exception. They say, when the officer says to them, "Can I search your car?" Far too often, a client of mine will say, "I told him he could." And once that consent is granted, it's a free-for-all. And the officers can search every compartment in that car, every bag in that car, and look for evidence of contraband or of crime. Another way it happens to an innocent person is one of these things that happens frequently. A client of mine will be driving on a suspended license, or they fail to renew their license, and therefore they're driving without a valid license at the time. Under California law, their car can be impounded. And once an officer seeks to impound your car, he's authorized to do an inventory search of your car, documenting the items that you have in it. From a legal standpoint, the excuse for that is they want to make sure all your property is accounted for at the beginning of the impound and at the end of the impound when you get your items back. But in reality, it's used by officers to search for contraband, whether it be drugs, weapons, stolen property. Oftentimes, people driving down the street unwittingly have marijuana, cocaine, or some other item in their car. They've forgotten about it for a while. And once the search is on, rest assured, when that item is found, they go from having a ticket for driving without a license to having a felony charge against them. So keep in mind, at any point in time, for these exceptions, a relatively innocent person can have their car searched. There's also another way. If an officer can state probable cause for his belief that there's an illegal item in your car or evidence of a crime in your car, he's authorized to search for it without a warrant. In other words, if the officer asks you, "Do you have marijuana in the car?" and you say yes, I hate to tell you, but he's got access to look for it now. If he asks you if there's anything illegal in the car and you say, "Well, I have a gun that's not registered to me," he gets to search your car for it. Also, there's a last exception I'd like to talk to you about because it's an important one for everyone to remember. If you get stopped by an officer and arrested in your car, the exception for search incident to that arrest allows him to search the compartment of the car that you're in. These are critical to remember. What's also critical to remember is, please, obviously, my suggestion is don't break the law. Obviously, people shouldn't have contraband in their possession, and they should only possess something like a firearm if they do so legally and properly. But in these instances, oftentimes, the search of a car leads to felony charges and severe felony cases. Having that been said, we take pride in our ability to file motions to suppress evidence and challenge the search of motor vehicles, challenge the seizure of evidence, and do our best to suppress it. The suppression of that type of evidence often takes a felony case from state prison to a dismissal. And there's no better way to conclude a felony charge than having a case dismissed. On our website, you could see some results like that. If you go to the case results page, we list a number of cases that we've achieved dismissals on behalf of our clients because a properly filed and advocated motion to suppress evidence yields the best possible results for our clients.